case briefs, and so much more. LSData's got what you're looking for.
When a New York corporation transferred its business to a Delaware entity back in 1918, it set the stage for a landmark legal dispute over conflict of laws. The New York corporation accused the Delaware firm of failing to honor their contractual agreement and took its grievance to court in Delaware. However, the New York corporation was granted the addition of interest to its judgment, aligning with the New York Civil Practice Act, not Delaware law. As such, the Supreme Court decided to intervene to settle an essential question. Should the provision in the New York Civil Practice Act apply to a federal court action in Delaware? The Supreme Court's involvement followed an affirmation of the court's ruling by the Circuit Court of Appeals, which leaned on Restatement Conflict of Laws Section 413 and Section 418. This stipulation maintains that damages for breach of contract, including interest, align with the law of the place where the contract is to be performed. However, the Supreme Court ruled differently, emphasizing the conflict of laws rules that pertain to the state in which the courts are located. The Delaware Federal Court's task was not to decide what the law should be, but rather to determine the existing state law. The specific notion that Delaware needed to uphold the New York statute under the Constitution's full faith and credit clause was also rejected by the court. The application of such a rule would be appropriate for issues directly relating to a contract's validity, not an incidental item of damages such as interest. In conclusion, the Supreme Court reversed the previous judgment and handed the case back to the Circuit Court of Appeals. The appeals court was tasked with following Delaware law for its decision, paving the way for a possible reset in the dynamics of conflict of law rules within diversity jurisdiction.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.